of working with him and with Eric Helland on the last volume that we just published called Challenged Justice in Pursuit of Judicial Independence. And so this is my opportunity to express to him my deep appreciation and deep gratitude for the fruitful cooperation between Hebrew U and his institution. And I also want to mention that we are planning towards the end of the year, in the fall, a continuation conference in Claremont of this effort. So now I would like to invite Professor Hiram Chodosh. Please.
Good morning, everyone. I'm Hiram Chodosh, and I'm terribly sorry that I couldn't be there with you this week. It's a big disappointment, but I did want to deliver a paper to you pre-recorded. It's December 31st here in Claremont, California, and we look forward to the conference and to this next year. Wish you all very happy, healthy, and fulfilling 2022. The title of this framework paper is Measuring Justice and Judicial Independence, the Impracticable Imperative. My colleague Eric Helland, who will be with you by Zoom, will follow up with his own observations in connection with the observations that I've made here. Now, thank you very much for listening in. As many of you know, I've spent nearly 3 decades working on the common challenges facing contemporary judicial systems: delay, corruption, interference with judicial independence, as well as undertrial, a serious form of delay in the criminal justice system in far too many countries, and physical and psychological coercion, including torture of the accused. And behind these harsh performance challenges are a wide range of fundamental institutional challenges, some neutral, others pointed: the proper, legitimate place and role of the courts in a democratic constitutional framework, the insufficiency of financial and human resources that courts need to sustain their effective roles, the crippling politicization and societal distrust of all branches of government, including the courts, devastating gaps in civic literacy, weak ethical commitments to rule of law values, and a poor practical understanding of how constitutional systems, including the courts, are designed to function. In this work, I have focused on 2 dimensions of these challenges and their interrelationships. The first is on the theoretical, methodological set of challenges in understanding the comparative nature of the problems and the relative effectiveness of remedies proposed in reform. The second is on the practical set of challenges in working through the policy, political, practical challenges of implementing large-scale judicial reform. This work is informed both by a number of concentrated reflections on methodological difficulties of any exercise of comparison and substantial field experience in a diverse array of national settings, from procedural delay in India to judicial corruption in Indonesia to judicial independence in Iraq. At the risk of reductionism, before I pose a half-dozen questions that help frame the aims of what we call the Measuring Justice Project, I want to share 3 critical challenges of judicial independence with some modestly reconstructive responses for this esteemed group to modify, sharpen, and implement. Challenge 1. Can we see with greater clarity and purpose that the judiciary is the most neglected branch of government? This is pointedly true in a world that has increased its dependency on strong, self-limiting, independent, impartial judicial institutions. We've not invested in judicial institutions in ways that are concomitant to the burdens they've taken on. Since the fall of the Berlin Wall, global commitments to democracy, forms of limited government, the rule of law, the move to private transactions economies, ways to take advantage of the benefits and reduce the harms of globalization, technological transformations beyond our dreams, the advent of universal human rights, and more recently, the rise of authoritarian backlash and political polarization of so many societies. Our judicial systems have suffered from greater burdens and diminished investments. In many places, including in the U.S. criminal justice system, we seem to be living in a Potemkin judicial village in which we rely on the beautiful facade of vital rhetorical commitments, only to find that there's little or less behind the walls to back them up in practice. In my modest experience, our understanding of court performance, especially in the common law systems, is skewed by our fundamental legal training in appellate decision-making. We spend way too little attention on the functional, practical challenges of the courts at the trial, especially pre-trial level, where the thin, burned rubber of the courts first hits the road. In sum, we may be arguably more honest naming this project Measuring Injustice. Challenge 2. Can we think harder about the nature and extent of the problems we're trying to solve? The problems of delay in civil or criminal cases, corruption, torture, judicial dependence are all complex phenomena in their own context, and the oversimplification of them or their remedies makes the words neater on the page, but doesn't advance common objectives in practice. At every stage, we have to think about the why in structural terms, and in the context of a specific society, with its own contradictions of values, goals, social, economic, political, and cultural conditions and challenges. One threat to judicial independence, for example, is private corruption. We have competing theories for why corruption occurs, political theories, power corrupts, economic theories about the risk of punishment, and cultural or educational theories. For example, the need to distinguish between right and wrong. Each explains, at least in part. None explains on its own. Each and all together provide just hints for reform that's more elusive than effective. This is not only a theoretical challenge, it's empirical. What do we know about the nature of the problem, the extent to which it exists, its impact? Which methodologies or technique can we develop to apply to measuring the problem of judicial dependencies? Challenge 3. Once we understand and can measure the problem, can we dedicate more time to fixing it? Here, for example, what is the role of our Mount Scopus guidelines in effective justice reform? What techniques can we develop to measure their implementation or effectiveness where reinforced? And where, with broader adoption, can they do greater good? To advance our response to these challenges, I'd like to pose a number of questions, a half dozen questions. This is all in the spirit of Nobel laureate physicist of 1946, Izzy Ravi, whose parents were credited by him with his success. When Izzy returned from school to home each day, his parents asked him, "Izzy, did you ask a good question today?" And at the end of the conference, we should ask ourselves, "Shimon, did we ask a good question today?" So here are my 6 questions for the day. Hopefully I'll get one of them right. Question 1. Can we, must we, measure justice? Can we measure justice? No, we cannot. It's impossible to do it. We may have no idea how to do it or do it well without assuming too much away. The problems of valuation, comparative measurement are just too complex, vexing, insuperable. And yet, yes, we do it. We measure justice. We do it here. We each have our own views of different legal systems, processes, results, in terms of whether they are just or not, regardless of theoretical clarity or any level of evidentiary accuracy that we may have achieved. We thus measure justice unavoidably, conclusorily, implicitly, even poorly. That may even be true of our assessment of independence. We pick and choose particular features from the mix and may not be able to account for the impact any one has on justice. Does life tenure or other legal protections for judges create independence we want? Is an independent judge more or less impartial? More or less just? We have good reason to say, but we do not have the right theory and empirics to know this is so. Recognizing these challenges, we have to commit ourselves to do it better or at least less poorly. Otherwise, our rhetorical commitments to justice and the indicia of just systems will remain hollow and indemonstrable. Therefore, it may be worthwhile to ask or to even push two seemingly incompatible ideas. Measuring justice is impossible and imperative. Recognizing impracticability keeps us humble. Focus on its necessity keeps us committed. We'll come back to that in a moment. Question 2. What is justice? To measure a phenomenon presumes we can define it. The question of justice is large and complex. In Gaddis's epic novel, On a Frolic of His Own, he starts with the observation that justice is for the afterlife. In this world, we only have law. What then is justice? And what kind of justice do we wish to measure? Equality before the law, or equality without the need for the law to intervene? Compliance with law, even if the law is unjust? Economic or social or religious concept of justice? Procedural justice? To make sure the process of decision-making is fair, impartial, accurate, consistent, and so on? Or new applications of economic, social, environmental justice? Questions outpace the answers, and any one answer generates more questions. Questions so daunting that we might easily give up. Without belaboring the obvious, measuring x, the variable of x, depends profoundly on the value assigned to the variable. Plug in justice for x, and we must ask what justice is, what it derives from, how do we see evidence of it or its failure? Is justice a matter of divine command in Plato, or natural rights in Locke, or utility in Mill, or a matter of property distribution within concepts of equality or equity? Is it a matter of consensual social contract measured by maximization of wealth as in Nozick? In criminal law, is it retributive, deterrent, restorative, or even just brutally incapacitating? Or regardless of whether a particular law is good or bad, is justice only a matter of compliance with the law, impartiality, and efficient administration of the cases that arise under it? And as facts may differ and change our sensibilities about the right result, is compliance so simple? As judges exercise judgment that draws on their experience, their social assumptions, their values, can we ever have true impartiality? Can judges be too independent to be just? Think of the judge in Jakarta who once remarked to me that judges should be independent of law itself. And is efficiency only measured by reference to cost and time, and not to the value of what's produced? Is quality only measured in terms of inputs, resources invested in the system, and not outputs, the decisions and their impacts? It's not clear to me that any one feature in any one system necessarily generates the value we seek to realize. Question 3. What is the role of the justice system within the society? What's the context of state and society in which justice operates? I think I've told you the story of the first major phase of judicial reform in Indonesia after Suharto, expressed in the blueprint for judicial reform developed in the early 2000s, failed to answer a central question. What are the optimal characteristics of a judicial decision? What is the product to be produced? Now, this reflected a deeper, unanswered set of questions about what the role of the judiciary in that society should or should not be, whether to resolve simple disputes between neighbors or to resolve the major legal conflicts of institutional authority and power. We know enough to see a conflict of values that complicates this entire exercise. Police states have less crime. Courts with liberal procedural rights have more delay. We have to decide what's important in these trade-offs, what effect we want to produce, among others. These questions vex, because in our constructive ambiguities we hide deeper disagreements. Every country believes in the rule of law, and that is a good thing. But it also has very different things in mind underlying that common belief. And that ambiguity can be destructive too. We can hardly measure justice if we can't recognize the deeper disagreement in response to the larger questions in our qualitative or quantitative measurements. Question 4. How do we compare and measure? Problems don't stop with underlying disagreements, even assuming we could all agree on a value or set of values for what is just, what is quality, what is efficient, what is independent. We still have profound methodological problems of measurement, the why, what, how of our qualitative and quantitative comparisons. When measuring, in any comparative sense, we have to align 3 questions and answers. 1, what is the purpose of our measurement? Why are we measuring? 2nd, what is the evidence, the data we seek to measure in pursuit of that purpose? And what are our methodologies for gathering and the data science or other statistical techniques for quantifying and differentiating those phenomena or data? And 3rd, what is the threshold for differentiating relative positives from the relative negatives? Each of these questions carries its own challenges. And as Einstein once said, we tend to measure only what we can count easily and fail to measure what really counts. Data on social conditions, court administration, survey results, both advance and skew our understanding of what's happening. This raises the issue of comparative methodology. How do we comparatively rate performance? Any measurement of justice is inherently comparative. An unjust result is evaluated only in comparison to a just one. An unjust system or process is contrasted with a less just one. Independence, impartiality, compliant, efficient are all relative terms and necessitate comparative frameworks. They also necessitate the evaluation of smaller features and designs and phenomena and the valuation of their existence or non-existence as important or not important. What are the indicia of judicial independence, for example, in terms of employment, appointment, tenure, removal, salary, and what value between 0 and 1 do we assign to the presence or absence of such features? These are open questions. As I've said, comparison has 3 important elements: the purpose, what motivates it, the content, the evidence to justify it, and the differential thresholds, the line between the existence of a condition and the non-existence of it. This is true on a macro scale, from big ideas of just or unjust to significant characterizations of key attributes of justice, fair, equal, impartial, to the micro evaluation of specific decisions. Measuring justice, therefore, has to contend with these methodological challenges. The values that underlie the characterization, the chosen evidence of justice or injustice, the evidentiary threshold to characterize the phenomena one way or the other. Question 5. How can we make this less daunting? How can we focus on the common, severe, pressing problems facing courts and not allow ourselves to be paralyzed by the methodological difficulties that I've described? Comparing apples and oranges is one thing, comparing fruit salad is another, comparing blended fruit, whether designer juices or smoothies, is a third altogether. And the philosophical and methodological challenges of measuring justice on a multinational or global scale are so vast, so vexing. It may be, as I've said, insurmountable to compare systems or societies in any meaningful way without breaking down the specific problems we wish to focus on into much smaller units of analysis. For example, we could start, as this project does, with the proposition that for systems to be just, judicial independence is a precondition. Political interference and financial corruption of the judiciary can't be tolerated. We might further agree that justice delayed is justice denied in both civil and criminal settings, and also agree that physical and psychological coercion of the accused, including the use of torture, is unjust. In other words, by focusing on specific aspects of justice, In other words, by focusing on specific aspects of justice, independence, efficiency, dignity, accuracy, and other values, and by studying common problems of where legal systems struggle to meet the values at least articulated by the societies they serve, we might, just might, be able to make some progress in measuring justice. Reduction here may be necessary both before and simultaneous with our more systemic assessments. So can we dedicate our rigorous attention to the values, evidence, and thresholds for characterizing judges as sufficiently independent, resilient, and repelling corrupt influences, efficient in taking just enough time to resolve cases effectively? This will help, but at the same time, we have to be careful that the rhetorical conventions we use, the ways we express things, not prefigure and bias our views from the outset. For example, we say, justice delayed is justice denied. But how do we know what's a delay? Delay itself presumes we've taken too much time. The systems that are quick may be too hasty to make accurate decisions. The systems that are slower may be trying to get it right, or they may have different values that thus require more time. For example, delays in India are in part attributable to horizontal or coordinate ideals of authority and very strong procedural rights and a lower priority placed on managerial expertise and discipline of judges. Judicial independence presumes that a separation and independence from political influences are more likely to preserve impartiality. But we should ask, why is this so? We are concerned justifiably about political interference. We could also equally be concerned about independence as a source of partiality. Independence of mind, taken to an extreme, may actually be a license for explicit or implicit bias. Without accountability, it may actually increase the risk of corruption. It may lead to a vertical interference by senior judges in the impartial judgment of more junior judges. It may help to tackle these problems in specific contexts of contemporary challenges of justice reform, from sociological sources of bias to ideological propensities, in systems where cases may be assigned randomly to reduce overall bias or not. These are tough problems in which to account. Question 6. What can we do about these difficulties within this project? To do this effectively, we have to argue simultaneously for the impracticability and imperative of measuring justice. As I've said, first, arguing impracticability will keep us honest about the limitations of our exercise. Pushing this thesis forces us to be clearer on our conceptions, our evaluations, our methodologies, to see and address the tough questions. Second, committing to the imperative of overcoming this impracticability will motivate us to overcome these limitations. This is where a large army of empiricists with new techniques in data and computer science come into play. This is why Eric and I are collaborating on this project. How can we take measurement seriously with the application of new powerful tools of empirical data collection and quantitative comparison? Eric will outline how empirical techniques have developed over the past 3 decades, pointing out some advances and continual difficulties in the literature, including the judicial independence literature. Based on these observations, we envision how these techniques may advance our understanding and improvement of justice systems. We still need to understand the qualitative value of each and every case, how it is resolved, what impact the resolution has, and so forth. There's no replacement for that. But just as in experimental science, the natural sciences, computation allows us to look at systems for new clues, new hunches, a more empirical understanding for what's going on in the system we're studying and how to fix it. From that systemic analysis, we go back to reductive experimentation with greater clarity and focus, only to repeat that cycle again and again. That's how we advance our scientific understanding in any field. That's how we will do it here. That's how we advance the cures to increase the effectiveness of our approach to improve the systems we have, whether they be human biological systems or legal systems. That's how we measure better and then do better what we measure in judicial independence, in the achievement of justice. And that's why we are honored to collaborate with Shimon and all of you here, both physically present and virtual, on this important 40-year-old project and dedicate ourselves to the next chapter of scholarship and impact. And I want to thank and congratulate all of you in that effort. And since it's December 31st, 2021, here as I record this talk, as we say, next year in Claremont McKenna College, next year in Claremont, California, next year in Jerusalem. Cheers, everybody. Have a great conference.
Thank you very much, Professor Hiram Chodosh, who delivered the presentation jointly on behalf of Eric Helland. Both are co-chairs of this conference, together with me, and also co-authors, as I mentioned, of the last volume on the book series on judicial independence. All books, 5 of them, were published by Brill Nijhoff, and this is an opportunity to thank also our publisher, Brill Nijhoff. Thank you, Professor Hiram Chodosh, for in fact setting for us a kind of roadmap for our work in this important project of measuring justice, kind of sort of a menu for us, what we should examine, evaluate, and study. We are looking forward to the second part of this conference, which will take place according to the plan in Claremont, in order to continue the work on the evaluation and laying down the measurements of justice.